People's National Congress Reform, PNCR, presents Nation Watch.
Good evening and welcome to this Nation Watch special. My name is Mervyn Williams, your host. Nation Watch is a production of the People's National Congress Reform. And this evening we're going to be talking about the local government election 2023. In my considered opinion, it's being mismanaged. Here to share his views from a technical perspective is Mr. Vincent Alexander, Commissioner at the Guyana Elections Commission. Welcome, sir. Viewers, just to let you know that earlier today, the People's National Congress Reform met with the Guyana Elections Commission and discussed a range of issues. And I must tell you that I am not impressed with the operations at GCOM. Mr. Alexander, let's talk a little bit before we get into greater details about the status at the Commission with respect to addressing the bloated voters list and the situation with the introduction of biometrics. I know that a long time ago, the purchase of equipment to support biometrics was in fact approved. What is the situation? Where are we? Are we going to get the biometrics anytime soon?
All right, Warren, let's start with what you referred to as the bloated list. Lots of people have zoomed in on the word bloated. I think we need to be clear in our minds, what is it we're really talking about? We're talking about the list of electors in a country of approximately 750,000 people. The electoral list of approximately 661,000 persons. And we know that our school population is somewhere in the vicinity of 200,000, which means that under no circumstance our list should be more than 500 and odd thousand rather than the 600 and something thousand we have. So we are seeing a list that represents over 100 and something thousand plus persons who are obviously not resident. And the word residency has issues, so who are obviously not in Guyana, who don't live in Guyana and who aren't here to participate. Separate and apart from this conjecture, about 750, 661, 200,000 school children, we ought always to remember that the only way people are taken off of our list is use a death certificate for those persons. That's the only way. Now, and that only way is peculiar to what has come out of the CJ's ruling. Because prior to the CJ's ruling, the Chief Justice's ruling, we would have periodic house-to-house registration, which would allow for us to get a new register of registrants based on a house-to-house registration exercise. That has been the trend since 1992. We last had such an exercise in 2008 with an understanding we do it every 7 years. So we were due for one no later than 2015. It was not done in 2015. But in 2018, the Parliament passed the 2019 budget and made a provision for house-to-house registration. There was no objection to this in Parliament, and the request for that appropriation came out of GCOM, which meant there was also no objection to it in GCOM. And why do I make that point? I make that point to say that all of the stakeholders in Guyana were on one sheet on the question of how we treat with our National Register of Registrants And our voters list up to 2018, when the budget for 2019 was passed.
Yeah.
It was only after a no confidence motion, there were those who changed their position and are now contesting all sorts of issues that they themselves never contested prior to the no confidence motion. So the point we want to make is no matter how high or how low others jump, they were doing no jumps and were themselves a party to an exercise that would have led to a new list being created in 2019.
Having advocated for it themselves since 2015.
Since 2015. And the monies were allocated. They did not oppose the allocation of the money in GCOM nor outside of GCOM. Now, so let me get back to this question of why it is so necessary to have that exercise. The numbers suggest it's necessary. But more than the numbers suggesting that it's necessary, we know that since there's no mechanism to take people off the list unless they die, and that further to that, we have no mechanism to take the overseas Guyanese who die off of the list, that thousands of overseas Guyanese are retained on the voters list. Thousands. And nobody can challenge that. Nandalal himself has come around to accepting that yes, there are overseas Guyanese on the voters list.
Who have died. Possibly died, yes.
Who have died, not possibly died.
Yes.
One could look at that announcement and see every night how many of them are dying. And it means that between 2008 to present, which is a period of how many years? 2008 to now, you're talking about 14 years. 14 years. All of the overseas Guyanese who have died overseas are likely still to be on that list, and that has to be thousands. In a country where the difference between the main contesting parties, the elections, is somewhere in the vicinity of 7,000 votes. That's the difference. And you have large numbers of overseas Guyanese who have died and who are resident on the list. Now, again, one may say, well, so what? And when you say so what, you have some guys around town who say, well, you know, our system for voting is so perfect that nobody can penetrate the system and cast a fraudulent. There are those who are frequently repeating that.
And possibly believing it too.
Well, I don't know if they believe it, because some of them themselves are up to wickedness, so they don't have to believe it, but they repeat it.
Well, a lie repeated often enough convinces the liar.
Yes.
Yes.
But the fact of the matter is this, that in the recount, the APNU AFC identified scores, hundreds, probably thousands of persons whose names were struck off by the presiding officers as having voted. APNU identified that many of those persons were in fact either dead or out of the country. But you can't take the APNU word for it. You know, you can't take the politician's word for it. You have to go beyond that. And so what the APNU did was to submit these names to GCOM in protest. And what GCOM did, under the signature of Justice Khalid Singh, these names were sent to the Chief Immigration Officer and to the Registrar of Births and Deaths. The Chief Immigration Officer responded, and if I and 2 names, and 199 were verified as persons who were not in the country at the time, but whose names were ticked off as having voted. Another list had, I think, 200 something, and again, about 70% were verified as being out of the country. So that let's go past all of this hullabaloo about good mechanisms and all of that. And let's clearly understand that no matter how good the system is, we now have irrefutable evidence that there were persons who were not in the country who voted. And therefore, it means that there has been mechanisms to penetrate the good system, whatever those mechanisms are. Unfortunately, we have not been able to find what those mechanisms are because GCOM has refused to conduct a review of its systems. A review of GCOM systems may well lend to an answer as to how this could occur. But GCOM has refused. When I say GCOM, I don't take collective responsibility because I have not refused. It is the three commissioners who represent the government and the chairperson who has refused to carry out this review. A review which merely sought to find out what are the fault lines, the flaws, the gaps in our system. They came back with this argument that no, you can't do that because under the Constitution, any matter about elections and results and things like that are to go to petition. But the fact of the matter is that these are not issues that are petition bound because we're not asking to find out who did what wrong. That's what the petition is for. We're not asking for a audit that would change the results. That's what the petition is for. We are simply asking for a normal activity in any project.
Review.
That is, at the end of the project, you review to see how well you have done. And if you have not done well, why not? And GCOM has refused to do that on the grounds that no politicians must look at any electoral related matter. Now, I want to make an interesting point here. If that is true, what do you have to say about the CY, the Commission of Inquiry?
Certainly not a court.
I will say this about it. The Commission of Inquiry is seeking to determine what happened in a very small window. A very small window. And the argument is that the president has the authority to set up a commission of inquiry under the Commission of Inquiries Act. And my response is twofold. One, what the Commission of Inquiry is doing is far beyond a review because the Commission of Inquiry is trying, in a sense, to determine what went wrong, how it went wrong, and who made it go wrong. That's what they're trying to do. So they're trying to do what has been argued should be done in a court. So those who are arguing it should be done in a court should well make the same argument. And my second point is this, that if that's what the Commission of Inquiry is doing, notwithstanding the general provision for a Commission of Inquiry to do that, the Constitution speaks specifically to how disputes at elections are dealt with. And the Commission of Inquiry Act is an enabling piece of legislation. It is therefore subordinated to the Constitution. And so although the President may have authority to establish a Commission of Inquiry, when one looks at the hierarchy of our law, and the fact that one law says matters of this nature are only supposed to be dealt with at the level of a petition and in court, then that does not, in my view, my layman view, necessarily give the president the right to establish a commission of inquiry to deal with the matter
That could have
which
been
the
dealt with
Constitution says,
Yeah.
according to all of these other people,
Yeah.
should be dealt with
by a court
by
of
the
law.
court. So we see there's a lot here that raises red flags about what the government in three instances. One, taking people to court for electoral offenses and being unable to properly prosecute those cases after a year has passed. And claiming that the court is slow when in fact a number of those cases have been held up because they have intervened, asking for these matters to be tried at the level of the High Court rather than the Magistrate Court, and taking that into a judicial process that has held up the actual trial. But they then turn around and say the court is slow. So on one hand, you have this issue of the cases that are not going anywhere. On the other hand, you have the petition, which they've objected to from a procedural perspective. So something was filed 2 days after the date. And at the level of the CCJ,
Allegedly.
at the level of the CCJ, there was a split decision, and a lot of people don't realize this.
Yeah.
The CCJ was not unanimous. 2 judges, the CCJ argued that this petition should be heard
At the level of the full
at
court.
the level of the full court. They argued that.
I want to come to something that touches on the integrity of GCOM. Pardon me if I sound too harsh. Last Tuesday, the People's National Congress Reform held a press conference. During the course of that press conference, the point was made that the list of electors specific to local government elections had not yet been released, had not yet been made available, had not yet been published.
And they were correct.
The people on the picket line in front of GCOM on the same day kept making the same point. GCOM issued a statement soon after, just about the time of the PNCR's press conference, in which Yolanda Ward said that,
And Ms. G.com said,
no,
she's
it
just
was,
a face.
yeah, well, her name was listed below there
She's
on
just
the
a face.
statement.
She's the PRO.
Very well. GCOM said that people must desist from spreading misinformation and disinformation, and that the list, in fact, was out there since November 4th. Today, at the meeting with GCOM, the PPP today.
I want to make 2 points in relation to what you said. GCOM has been media shy for over a year. Media shy. GCOM has suddenly come alive in terms of press releases since one Commissioner Rui joined the commission and pointedly says in those meetings, we need to put out a release. So it seems like he's running that aspect of GCOM, the PR aspect. So the first point I want to make. The second point I want to make is directly related to what you said. GCOM has not, prior to over the last weekend, put into the public domain any form of list that is specifically related to local government areas and their constituencies. It's only over the weekend that they gazetted an order indicating that they are now going to issue a list,
You're now going to extract.
and to post a list, which is based on local government areas and the constituencies. And let's break that down. We are going to an election. We are going to elections, not an election.
Yes, 80 of them.
80 elections in the neighborhood democratic councils and in the municipalities and towns. 8 elections. So that really we have to have 80 lists. Each list specific to a neighborhood democratic council and to a municipality. 80. And so in these lists,
And 611 constituencies, I gather,
in those
within those 80.
within those
yes.
80 bodies. And the reason why we have to have those lists, because local government election requires that for someone to vote in those elections and or for someone to be nominated to be a councillor, a candidate to those elections, the person has to be residing within the constituency within the local government area. Has to be configured around the local government area and the constituencies. And the fact of the matter is that prior to this last weekend, there was no such list. However, GCOM carried out an exercise called claims and objections, which is intended to ensure only eligible persons are on the list.
No.
Now, if
This-
you do in
this-
local government,
This is a point I'm coming to, because look, we are what? 13 days away from nomination. The list was reportedly supplied today. Lists have got to be disseminated all across the country to 611 constituencies. That's an increased number of constituency from
over
2018.
590 something.
Right. Now, if these dates that GCOM has set are anything to go by, it means that, first of all, you have to have your lists going out. You're talking 3 to 4 days getting them out there. And you also have to have claims and objections specific to constituencies, because someone may offer themselves as a candidate in constituency A of local authority 1. The boundary may have been shifted, and that person may now be in constituency 3. Someone will have to have an opportunity to object to that person contesting in a constituency where he or she does not reside. That timeline does not offer that opportunity. How do you treat with that? And then when you're done with that, we'll deal with boundaries.
The issue is not the timeline there at all. Let's go to basics. Claims and objections are intended to ensure that only persons who are eligible are on an electoral list. We are dealing with 80 elections. Therefore, claims and objections should really be conducted in relation to 80 electoral lists. Claims and objections were done, not done on the basis of 80 electoral lists. It was done on the basis of the national lists
10 districts.
and the divisions therein.
Yeah.
The divisions therein, 10 divisions, 10 districts. So that one was not given the opportunity to do claims and objections specific to a local authority area and its constituencies. So that what would have occurred is that many persons in a country where there's all of this movement based on the housing schemes that have been created, those persons having moved out of a particular local government area would not have necessarily made a claim to be registered where they reside. So we have a lot of people who live in areas where they're not registered, and they're not entitled to vote in those areas. They're entitled to vote, but administratively can't vote because they did not do the claim, because the way claims and objections was administered did not say to them that, you have to. It's necessary, it's compulsory if you're going to vote in your area. The people are of the impression that they can go back where they used to live and cast their vote, which they really shouldn't be able to do. And such people, not having made a claim to be moved, should be objected to. But if you don't conduct claims and objections in relation to a local authority area, then no one objects to them because it sounds like a normal national elections. Once they're in the country and then they list, they're legit. But you're not legit for local government if you're not living in the local government area. So from the very inception, GCOM went wrong because it did not specifically say to the population, we're doing claims and objections, and that unlike national elections, residency is an element that can be used for an objection because the local government law specifies that anyone who is, for anyone to vote, he or she must be residing in, and they
And
have
registered in.
and registered. What residing in means, including where you eat,
Where you sleep.
and things like that. So it's a very serious provision. But people were not given the opportunity to operate under that provision because our claims and objections were done based on the normal divisions of Guyana. And once you were in Guyana, then there was no basis for an objection to be raised because it was conducted as if it was for a national election rather than a local government election.
Consequent upon which persons have been incorrectly enfranchised and some disenfranchised
Correct.
by the process.
And so it brings us to the second aspect of what you said. At the baseline, things have gone wrong. Now, things having gone wrong at the baseline, you have some other issues. If you are going to be creating constituencies at a time when you have already finalized your list, or at a time when it's a small number of days between finalizing the list, then the voters, the candidates, the parties are in no position to do the work required to identify their candidates, even to create symbols in relation to a particular area.
Or to find persons to nominate.
And to find persons to nominate because the time given for this is very short and people can be making mistakes because you can go to the list that they previously had, the preliminary list, so to speak, pull in names from that list to find out that those people are not really eligible because although their names may be on the list, they are not residing in those areas. And so there could be a lot of confusion about who are nominated and who are not nominated. There could be a lot of confusion about which constituency someone is identified with because it's only now these constituencies are being rolled out, and that's an issue by itself.
Yes.
And since they're only now being rolled out, somebody who lives in one area where they've changed the boundaries, maybe, but now, for all intents and purposes, has found himself physically somewhere else.
Right. Viewers, you're tuned to Nation Watch Special Edition, and we're discussing the mismanagement of local government elections 2023. My guest is Mr. Vincent Alexander, Commissioner at GCOM. We're almost down the halfway mark on the clock.
People's National Congress Reform, PNCR, presents Nation Watch.
The minister responsible for local government Hello and A very good Sunday afternoon to you all. It's Sunday, 11th December 2022. Well, it's going to be an idle Christmas for most of us, but we'll talk about that next Sunday, God willing. Today, we are going to discuss with Mr. Vincent Alexander, who is a commissioner at the Ghana Elections Commission, a number of very, very important issues relating to local government elections. And I welcome you all to this Sunday, 11th December edition of Nation Watch, even as I welcome my guest, Mr. Vincent Alexander.
Thank you very much, Marvin.
It's always an honor to have you here, sir, to simplify matters for us. Quickly rushing into the business of the day, nomination day has been cancelled. Nomination day has been cancelled. It should have been tomorrow, I believe. So a number of things are going to happen from now on. Tell us what are the consequences, please, sir, of the cancellation of nomination day for local government elections 2023.
You're quite correct, Marvin. Nomination day has been cancelled. It should have been tomorrow. The new date is still to be determined. And one should understand that that cancellation has to do with the fact that the manner in which GCOM went about preparing its list has been accepted to be wrong and therefore needs to be corrected. And therefore, we need to go into a process to prepare the list in the manner that the law requires it to be prepared. I want to say that when GCOM last met, there was no agreement on the way in which the list should be prepared. This judge, the jury is still out on that. I'm saying that because I've seen some attempts to suggest that there's a particular way it will be prepared. That matter is still to be determined, and the determination of that matter will then lend to the new timelines leading up to the election. The postponement, the cancellation of nomination day means that we cannot hold elections on the day that it was intended, that's March the 13th, and the extent to which we have not yet determined the way in which we will in fact approach the list. There are different views on that matter in the Commission. Different persons think that there are different starting points relating to different statutes in our laws. Still has not been determined, and it's only after that has been determined that we'll be able to identify the deadlines and to specify when elections would be held.
You, together with your colleagues, Mr. Charles Corbin and Mr. Desmond Trotman, you have been working at the level of the Commission, bringing a number of these points into focus. Over time, those points have been rejected, essentially. There was a recent meeting with the opposition and the GCOM, the Ghana Elections Commission, following which there was the filing of a court proceedings challenging the manner in which things were happening. Do you see the efforts of the opposition and the challenge, the legal challenge, as helping your efforts in any way and complementing what it is you're doing in the interest of Guyana?
Well, I don't think that what we have been arguing for differs from the propositions of the opposition. And I do think that the strength of our own argument, the fact that the matter is before the court, and the intervention of the opposition would have weighed in on what is now happening. In fact, the CEO himself said that at the last weekend, having had the court matter brought to his attention, he had an internal review of the matter, and it is based on that, his own internal review, that he came back with the proposition that, but the way he coined it was that he wanted to be responsive in a democratic way to the opposition. So he wasn't accepting that they had gone down the wrong road. He was attempting to say, look, what I'm doing here is trying to be responsive, trying to be democratic. But the fact of the matter is, the argument put forward by us suggests that they had gone down the wrong road, and the court would have to make that final determination as to whether they went down the wrong road or not. But now, still have to make the determination, given the acceptance that we're not going to continue down the road we were going down. which road we're now going. I think we have a kind of 5 junction road. Take a choice of where we go.
You're in Linden then.
And we haven't yet made that decision. That decision should be made, hopefully, on Tuesday.
You spoke about the list. There are a number of factors which would influence how you approach addressing the issue of the list and its preparation. And very interestingly, there's a there's an article in Chronicle dated, I believe, the 9th, in which one Barrett Jagdeo attempts to suggest to the nation and the world at large that both the opposition nominated elections commissioners and the parliamentary opposition are really not making any sense. This is a suggestion. The claim, I quote the article, the claim of the political opposition that local government minister Dharam Lal cannot demarcate boundaries of local area authorities is untrue. Now, this is propagandistic. No one ever says that the minister lacks the legal authority to delineate boundaries of local authority areas. The issue has always been, Mr. Jagdeo, that the Minister of Local Government does not have the lawful authority to do anything with respect to boundaries of constituencies which fall within the local authority area. So this is a lame duck attempt at pouring cold water on your efforts. But that aside, how important is this issue of constituency boundaries to the preparation of the list as is required by law for local government election? And what are the impacts of the decisions which are viewed as unlawful taken by the Minister of Government, local government, with respect to those boundaries?
That's a very important question. Let me first of all say that Jagdeo is exposing this nation to a significant amount of trash and trying to confuse people. And there are people in GCOM who are trying to find ways to support what he's doing and what he's saying. The law is unambiguous that the minister can establish boundaries for local government areas. A constituency is not a local government area. The only law that makes a reference to constituencies in terms of who has the authority is the Local Government Elections Amendment Act, Section 38A, 4 and 5.
Yeah.
And 5 unambiguously says it is GCOM that has to either combine or divide the divisions for the purpose of creating constituencies.
Right.
And so Jagdeo can jump high and he can jump low. That is what the law provides for. And the public needs to understand there's a difference between a local government area, which is the area encompassing what's called a neighborhood democratic council or municipality, and the constituencies which are parts of. So yes, you have to establish the local area first, and the minister does that. But having established a local area, he's then authorized to indicate how many seats are going to be constituency seats. Once he has done that, it then signals to GCOM how many constituencies should be created, and GCOM has the authority to create those constituencies. This is interrelated to the list. Why? The problem we've had with the list is that the list was not extracted on the basis of local government areas and constituencies, and therefore the electorate were unable to make objections on the principle of residency. Local government elections provides for residency. You must be resident in the constituency of the local authority in which you're either going to vote or going to contest. And therefore, when we have claims and objections, an elector must be able to go to the list of the constituency and to see if there's anyone on that list who does not reside in that list in keeping with the provisions of the law about residency, and to object to that person being on the list. That was not provided for. That was not done. Hence, we have to redo this whole question of the preparation of the list. And as I'm showing you, there's an interrelationship between the preparation of the list and constituencies, because GCOM has to use the constituencies as the basis for the specific lists, because the lists are by constituencies. We have elections of over 500 and something persons because each constituency will have a person elected. You have to identify the voters who are eligible to vote in the particular constituency. So that even as we now seek to determine how we will approach the question of the list, we have to look to see what are the demarcations of the LGAs, the local authorities, and the constituencies, so the configured list corresponds with that. And in that regard, I want to say, GCOM has issued a press release seeking to respond to what they say is misrepresentation and misinformation by the press. But in issuing that press release, GCOM has itself sought to confuse the public. We in GCOM are in a position to know what were the constituencies that the minister sought to configure, because he published two orders, Order 40 and Order 50.
Right.
And in those orders, sought to specify constituencies, which he has absolutely no authority to do.
And there was 39 as well.
Right. Yet GCOM is thumping its toe and telling the public, well, we don't know that this has occurred. We have to check to see. But the minister has legal authority to establish local government areas. Yes, he has. You don't need to tell the public that anymore. But they even go on to say he has authority to deal with divisions. The minister does not have authority to deal with divisions either.
Well, it's rather interesting, is it not, that in the same article to which I earlier referred, the chairman of GCOM, chairman of GCOM had this to say, and I quote her from the Chronicle report. The chairman pointed out that those changes made to the boundaries of local authority areas and any changes to electoral divisions within those local authority areas are within the legal authority of the minister, confirming what you've just said.
The minister has
She goes on.
no authority to change divisions.
Yeah.
In fact, we have to use divisions. The law specifies that those units which are referred to as people's cooperative units, for all intents and purposes, are the divisions. At the level of local
Precisely.
government, we do not interfere with divisions. What we do is use the extant divisions.
And then she goes on to say, contradicting herself now, she emphasized, however, that if the minister sought to form or change the configuration of constituencies within those areas, he would have usurped the power granted to the commission to combine and subdivide electoral divisions to form constituencies.
Here is where I have a problem with the chairman of GCOM. She is saying, if he did.
If he did, but he has
The
done it.
expression is not if. He did it.
Yes.
And GCOM knows he did it. She referred to the gazetted order in her press release. And if she knows about that order shows that he did seek to do it. It's not lawful. He did seek to do it. And more than that, if one goes to the lists that GCOM last posted, those lists are in conformant with what the minister wrongly did. So GCOM has knowledge and is complicit
Yes.
and trying to blindfold the public on this matter.
Yet the chairman goes on to say, and I quote from this article, if such were the case, the minister would have acted outside of his legal remit. What manner of madness is this? I mean, how could you sit on both sides of the fence on this issue?
Well, it will tell you where she will eventually fall.
Mr. Alexander, tell us more about, you refer to Order 50, you refer to Order 40, and there's also Order 39 of 2022, which were issued by the minister. And we believe from the outside that GCOM, in fact, ought to have acted instead of the minister on a number of these issues. And we believe, based on information, that GCOM ought to conduct some level of consultation in doing the things that are required to be done leading up to a possible order of this nature.
GCOM in the past, for elections 2016, local government elections, and elections 2018, did what the law required it to do. And what the law required it to do is to determine the demarcation of the boundaries of constituencies. More than just doing that, GCOM had a process where at the local level, involving the registrar the registration officer and the political scrutineers, they were the ones who did the initial work to determine what recommendations would be made. They would then make recommendations to GCOM per se, that's the commission, and the commission would then determine the final boundaries. So that we have a situation now where, as far as I'm concerned, that work has to be done as a precursor to any work in relation to the list, because the list has to reflect that configuration. We have to go back on the ground, and where the minister has sought to impose himself, GCOM has to do its work. It may turn out in instances that what the GCOM comes up with coincides, but GCOM has the authority and has to do its work. And this attempt by GCOM, in form of a press release, to suggest that nothing has been done, really puts GCOM on the block. Because if one looks, for example, at Tuflok Sanditon
Potential.
Tuflok
Two-flood potential.
potential, one can see in the order that has been issued that Rizland Potosi
Yes.
has been included in that local authority, being delineated by that order as a constituency. The minister cannot
unlawful act.
do that. What he can do is extend the local authority to include Rizland Potosi, but cannot designate Rizland Potosi as a constituency.
The same was done in Lamaha.
Similarly, here is Jagdeo arguing that we have only readjusted the wrongs that the PNC did.
Well,
The fact of the matter is, if you go to the highway, in Lamaha Yarokabra and in Haruni Yarokabra, those local authorities did not exist prior to the last elections. And therefore, you can't be adjusting something which you said existed before. It did not exist. It did not exist. And what they have done is to resize one authority and downsize the other, and in that process have also interfered with constituency boundaries. The same goes for Mabaruma.
Yes.
Mabaruma is a township created under the David Granger administration. There's nothing pre-David Granger that the PNC tampered with in terms of Mabaruma. They created Mabaruma.
Yes.
Now they've sought to extend Mabaruma, and they have the authority to do that. But in extending it, they've sought to identify a constituency which they have no authority to do. So Jagdeo is trying to confuse the public with his trash, accusing people of doing what he does best, accusing people of lying.
Now, you refer to those new local authority areas, the two in Region 2, the Pomeroon River, the two on the highway, the two involved in the Yarokabra area. They were in fact established in law since 1990, as I understand it. But they were not promulgated as local authority areas by the PPP while in government.
Quite correct.
So it was a case where the AP and UAFC was righting the wrong done by the People's Progressive Party, where they refused to give local authority status to these 4 local authority areas and the people who reside within them. Now that they've been established, they're trying to manipulate it for political miles. And in addition to that, the Upper Boroboro Arnaputa NDC was actually created by the Granger administration in the North Rupununi to cover an area not provided for on the local authority area or Amerindian village. So I really don't know what they're talking about, but what I want you to speak
Let me respond to that question this way. In 1980, Constitution provided for the system of local democracy.
Yes.
A reference was not to local democracy before, and for local democratic organs. As a consequence of the 1980 Constitution, you had the Local Democratic Organ Act of 1980 as well. It is under that act that the entire country was demarcated into 6 levels of local authority.
Guided by one Hugh Desmond Hoyt.
Under the leadership of Hugh Desmond Hoyt. So you had the region, the sub-region, the district, the community, the neighborhood, and the People's Cooperative
Cooperative
Union.
unit, right.
All of those areas were demarcated in keeping with the provisions of the Constitution and the provisions of the Local Government Authority, Local Government Democratic Act. So those divisions, those positions, those things are in place. They being in place, the ministers, however, authorized to pronounce which them at which time would become a local government authority area and define the local government council for the area, including the number of councillors. That's what the minister can do. The APNU AFC advanced what had been done in 1980 by establishing more of those local authorities. That's what they did. In doing that, they have the right to define the local authority area on one hand, and then GCOM defines the constituencies. What the APNU AFC did was to define the local authority areas, and GCOM then defined the constituencies. So the PVP, in saying they're pushing back using the wrong authority, because they cannot push back to change constituencies through the act of the minister. Any changes in constituencies has got to be done, irrespective of how the constituency, irrespective of where the constituency is, has to be done by GCOM, and that is not what they are seeking to do. They sought to do it on their own.
This article, I want to come back to this article very quickly. This article says, and I quote, noting that former Minister Bulkan did a terrible job when he changed boundaries. Jagdeo said that the recent action of the PPPC government chose to correct those mistakes. Now, you referenced this particular issue a minute ago. My recollection tells me that there were consultations conducted, and beyond that, that Minister Bulkan took to the National Assembly and had a full debate on these issues, full participation of both sides of the House. And GCOM was involved in doing its statutory functions, and the minister, on the back of all that had been done, then came out and lawfully issued orders giving life to some decisions. Comment on that, please.
What we have to be clear about here, the work done by Minister Bulkan that was carried in an order under his signature was the creation of local government areas, not constituencies.
Precisely.
Local government areas. And even in doing so, I'm advised he consulted.
He did. I was part of some of those.
After that would have been done, GCOM created the constituencies, and the order in relation to constituencies was issued not by the Minister of Local Government. It was issued by GCOM.
And in this instant case, GCOM did not issue any orders with respect to matters leading up to where we are with local government
GCOM has
election
issued
2023.
no order. GCOM has hunky-dory gone along with what the minister's done. And interestingly, when I posed the question at the last meeting, have we done anything in relation to the minister's unlawful act, the CEO's response was, no, we had not done so. That was his response. Because he, in GCOM, was one who said that he did not know the minister had any authority to create constituencies. But in the last meeting, when I posed the question, where are we in relation to our list and its configuration of constituencies, he said that he had not done anything congruent to what the minister had done. The orders and the lists that GCOM have put up will show that GCOM, in fact, unknown to the commission, did give recognition to what the minister had unlawfully done and published. The last list that they published configures constituencies in keeping with the wrongdoing of the minister.
Local government elections, the GCOM dilemma. Clearly, GCOM has problems. GCOM is required to do some certain things by law. GCOM is pandering towards political instructions and political actions very clearly. Mr. Alexander, in the remaining 1.5 minutes or so, where are we heading with local government elections? Do we stand a chance of seeing Guyana going to the polls in 2023?
I would think it is possible to go to the polls in 2023. Exactly when is still to be determined.
Thank you very much. Ladies and gentlemen, you've been tuned to Nation Watch. We've been discussing the local government elections, the GCOM dilemma. My guest, Vincent Alexander, Commissioner at the Guyana Elections Commission. As always, very, very insightful and very articulate in addressing the issues at hand. Thank you very much for joining us. Thank you very much for staying with us. Thank you, Mr. Alexander, for sharing your time
Thank you very
and
much
your
for having me.
knowledge. And looking forward to see you again by God's grace next Sunday. Stay blessed.